Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Good morning, everyone. Today's Tuesday, again here at 10 o'clock on the Bottled Business Sense show. Welcome to all of our viewers out there. And if you're brand new, welcome to the Bottled Business Sense show. I'm Rick Moscoso, one of the co-hosts this morning, and our keynote speaker, as usual, is Mr. Bill Bernard, and he's right there on the other side. How you doing, Bill?
Hey, good, Rick. Good. Rick and I were talking before the broadcast. I was just thinking about this, and he said, I wonder if we should tell everybody what's been going on because we haven't been on in a while. And I said, well, this is free information, and people either take advantage of it or they don't. But truth be told, I've been a little under the weather. And, that's what happens when you get old, Rick. You get things happen to you that don't typically otherwise happen to you. But as you can see, I'm in my typical Hawaii dress here, and I'm enjoying life again and helping people out with estate plans and business ideas. And, we're here to serve. So we're back on the air again, and we'll try to do maybe 2 or 3 shows a month, maybe sometimes 4 shows over the course of 3 months. It just depends on the time that we have and how busy Rick and I are. So it's good to be back with you. And today we're going to talk about important beneficiary designation rules for your IRAs and your retirement accounts. I get a lot of questions on this. In fact, just this morning, a neighbor of mine asked me if I was taping a show today because he knew it was Tuesday. And he said, what are you taping? And I told him, and he said, boy, that's really important stuff. I'd like to learn more about that myself. So lo and behold, it worked out pretty good, Rick. And we're going to talk a little bit about the fact that IRAs and 401ks are important. And typically, we've always said there's really no need. And the key word is need. We don't need to put IRAs and 401ks in our trust because they have their own built-in beneficiaries, which allow you to avoid probate, typically speaking. But that doesn't mean you can't put them in your trust. And so we're going to go over some of these things and indicate, first of all, that without a properly completed beneficiary designation, your account will, in fact, get stuck. And it's not going to be able to be moved to anybody until it goes through probate if you don't have a designated beneficiary. So that may seem like common sense, but you got to do that, right, Rick? I mean, you got to have somebody that you're going to leave something to.
Yeah, well, isn't that a requirement of filling one out?
Well, you'll be surprised how many people create IRAs and either have a beneficiary who passes away, or they have a primary beneficiary and not a secondary beneficiary in case someone passes away, or in case they get what's that nasty word, divorced. I mean, there's a lot of different scenarios where you wouldn't have a beneficiary. But anyway, you must have a completed form in order to avoid probate. Now, a beneficiary designation is a written and signed statement placed on record with your account custodian. So who's your account custodian? Well, I don't know, maybe you have investment accounts with Edward Jones. Whoever handles your investment accounts, and it specifies upon your death who inherits your IRA or your 401k or your HSA. You know what an HSA is? Anybody out there? It is a health savings account where you put a certain amount of money away per month with your employer, and it's allowed to be used for the paying of health expenses that you may incur. It's treated much like an IRA. And of course, the fourth one is life insurance. You got to have a beneficiary to your life insurance policy. Without reference to a deceased person's will or trust, and without the involvement of probate courts, this designated beneficiary status in these types of accounts will work. So remember, designations that are used are designated on these forms and do not need to reference any estate documents that you may or may not have. Now, moving on, to have a valid beneficiary designation, when you fill out these forms, you're going to need certain things. One is the designation. Use your institution's custodian's form to designate your desired beneficiary. And what do you got to do? You got to list their name, the city and state they live in, their date of birth, and their relationship to you. Okay? You can also list one beneficiary or multiple beneficiaries. So you may have 2 or 3 beneficiaries as your primary beneficiaries. And what's going to happen? Well, your account, whatever's in it, is going to be split by the number of beneficiaries that you have. You can also have a secondary beneficiary, as I briefly mentioned earlier, right? One person, something happens to the primary beneficiary, you have a secondary beneficiary in place who becomes primary. Number 2, you must sign the designation. And number 3, what about a spousal waiver? This is important. If you have a spouse and you have not listed your spouse as the primary beneficiary, then your spouse must sign a spousal waiver agreeing to allow someone else to become the primary beneficiary. This is required as a matter of law. A failure to do this will result, at best, in your surviving spouse receiving at least half of your account upon your passing, and the rest going to your secondary beneficiaries, assuming you have secondary beneficiaries. So if you want a different primary beneficiary other than your spouse, you better get a spousal waiver. Otherwise, your spouse is going to get it all if you don't have a secondary beneficiary. If you don't get a spousal waiver and you have a secondary beneficiary, then your spouse is going to get it probably at least half. So you get the spousal waiver, you have your primary beneficiary getting it all, and then your secondary beneficiary is getting it all if something happens to the primary beneficiary, which is someone other than your spouse. Again, only if you have a spousal waiver. You have to get that as a matter of law. Again, no spousal waiver, and you have a primary beneficiary other than your spouse is probably going to get at least half of that. And that's going to disrupt your plans. Coordinate your IRAs, your insurance policies, your 401ks, your health insurance, your health savings plans with your estate plan. If you list your trust as the beneficiary of your IRA or 401k or other retirement account, you must provide a copy of that trust to the institution, to the custodian. In the example I used, Edward Jones, because the trust must have readily identifiable beneficiaries for the money to be distributed to. So if you list your trust as the primary beneficiary in one of these accounts, your trust is going to get the money, but the trust has to know how to split it up. So you better have your beneficiaries in the trust designated properly. So as the primary beneficiary of the 401k or IRA, the custodian knows how to divvy up the money. Your beneficiary designation on your retirement account or bank account will control over a will which states someone different to receive your assets. This is another issue that we come across. Let's say you don't have a trust, but you have a will. And your will says who's going to get what. Well, you still got to go to probate court, right? Because even with a will or without a will, you got to go to probate. Wills by themselves are worthless, in my opinion. I've said that a million times. But let's say you just have a will, and you say Joe, Mary, and John are going to get whatever you have left. Your beneficiary designation on your retirement account or 401k or IRA will control over that will. So whoever is listed as your primary beneficiary, if that's different from who you have listed as your beneficiary in your will, that's going to control over the will. So you don't have to go to probate on those accounts because you've gone to the trouble of appropriately listing your beneficiaries in your 401k or your IRA. Now, here's where some of the issues come up. We mentioned it a little bit earlier, divorce. My goodness. There are so many cases where people get divorced and fail to change the beneficiary status on these accounts. Guess who ends up getting all the money, folks? Oh, well, you know, they may end up getting all the money anyway in the divorce process, but you know what I'm talking about. They're going to get what you didn't really want them to have because you didn't bother to go back and change your beneficiary status. What if you get a new estate plan? You better go back and ensure that your wishes in your beneficiary designation for your retirement accounts, IRAs, and bank accounts match up with the terms of your trust if, in fact, you leave your trust as a primary beneficiary, right? If you make changes in your estate plan, you better make sure that if you're leaving your trust as the primary beneficiary, that those are the people that you want to get this IRA or 401k. What if the trust is the secondary beneficiary? Well, you have a primary beneficiary gets it all, but if that person is deceased or you get divorced, that secondary beneficiary may come into play. You get divorced, you name a new primary beneficiary, or you already have a primary beneficiary as your spouse, without getting divorced. Something happens to that spouse. Now you have the trust as the secondary beneficiary. You want to make sure that you have the people listed in that trust who you want to get this money. And if you make changes in that trust, you want to make sure you want to still leave your trust as either the primary or the secondary beneficiary, because whoever gets the money from the trust is going to be given the money based on who you have as the beneficiary in that trust. So there are a lot of things to consider here that people don't typically consider, and that's what I wanted to point out in the show today. What if you have a new child who was not previously identified as a beneficiary in one of these accounts, and you want to list that child or include that child? You better make that change as either a primary or secondary beneficiary in that 401k or that IRA. Now, the question arises when to list your trust versus your spouse or children directly. We've been hedging around this. We've been talking about it. When do you want to list your trust as the primary beneficiary, or do you want to simply list your trust as the secondary beneficiary? Well, as a rule of thumb, most estate planning attorneys recommend that for your IRA or your 401k, you list your spouse as your primary beneficiary and your trust as your secondary beneficiary. Why would you think this might be, other than the fact that maybe you want your spouse to get all the money and not any of your children from these particular accounts? Why would you think that might be?
Well, what if your spouse passes away, right?
Well, then the trust would be your secondary beneficiary and they would get the money. But no, here's why. Have you ever heard of a spousal rollover, Rick?
No. Wow.
So
in the terms that you
yeah, we don't want to confuse it with any kind of illicit behavior. We want to talk about in terms of trust and estate law, right? Yeah. So a spousal rollover is you have an IRA or a 401k. You list your spouse as the primary beneficiary. That spouse can now roll over that money that she's getting from your IRA or the 401k, and it's treated as an IRA for the spouse, right? So the spouse is not subject to any required minimum distributions, and therefore the funds are treated as a traditional IRA or a Roth IRA, whatever IRA you had, for the spouse, just like it was for you before you passed away. So there's tax implications there, right? You allow the spouse to now roll the money over as opposed to taking it out and creating her own IRA, whether it be traditional or Roth, and now she doesn't have these required minimum distributions that she has to take, which when you take those distributions, you're taxed on them. You can take them as you please, realizing, of course, that if it's not a Roth IRA, you're going to be taxed at some point on whatever you take. Now, also, certain provisions in your trust can be designated to protect funds from creditors, misappropriations from inheriting children or heirs. So you may want to list your trust as the primary beneficiary, when you are concerned about what your children may do or what kind of creditor issues you may have, because your trust can provide for that. Also, your children and other heirs under your trust who are listed as secondary beneficiaries on your form would receive the funds from your retirement account in an inherited IRA. So you could create what's called an inherited IRA, which would have required minimum distributions, okay? But it would be called a stretch IRA because this allows greater tax strategy and allows them to extend tax-free or tax-deferred whatever benefits they receive from this 401k or IRA. So in other words, let's go over that again. Certain provisions in your trust can be designated to protect the funds from creditors and misappropriations from inherited children. However, your children or other heirs under your trust who are listed as secondary beneficiaries on your form could receive the funds from your retirement account in an inherited IRA that would have required minimum distributions that they would be taxed on, but that could be stretched out over time. So you really should talk to a tax person in regard to this as well. The point I'm making here is if you list your trust as a secondary beneficiary, you can set it up to where if your spouse isn't available, your trust can control, and if your trust controls, you can get you can have protection from creditors, and you can also have this stretch IRA for your children that's created that otherwise wouldn't be if your trust wasn't listed as a secondary beneficiary on your 401k or your IRA. So this gets a little complicated. It needs to be discussed with your estate lawyer and with your tax person, but I guess the point of the show I'm making today is that you really need to pay attention to these beneficiary type status, both primary and secondary, because when you set these accounts up, you can do it in a lot of creative ways. Just another reason why you should consult with an experienced estate attorney and probably your tax person as well. So I hope that's been somewhat enlightening, and I hope that clarifies some issues which a lot of people have been asking me questions about over the last few months.
Yeah, Bill, thank you very much for that information. I know it can be a bit confusing and complex depending on the extent of what you have. But folks, if you do have any questions, Bill's always here as a resource to initially contact. See if he can answer some general questions for you. You can reach him at the information here below this video, and just reach out to him. You'll always get a response back.
Yeah, and be sure to remember that you want to make these designations, both primary and secondary. Start there. If you do that, you're in good shape. Consult with your estate planning attorney if you have questions about making your trust, and please do get a trust. If you have a trust that you want to make as either your primary or secondary beneficiary, that's the real moral of the story for today.
Bill, that leads me to another question real quick. You mentioned trust, and what if somebody doesn't have a trust? What would you suggest the first thing they do?
Well, please call me and get a trust. Listen, I offer trusts online. You can go to protectyourestate365.com or PYE365.com. They both come up. You will see videos there. You will see drop-down questions. You will see, most of all, an astounding price for not only a living trust, but a pour-over will, powers of attorney for assets, powers of attorney for healthcare, living will, trust designation, trust certification. All of these things are included in my price which, if I believe I remember correctly, is $15.99. I mean, shop around, folks, and see if you can get an assisted, and by assisted I mean an attorney performing all of the duties and creating these documents for you for that price. And it's a sales pitch, but nobody's going to do it for me, and you can't get what you don't ask for. So ask me those questions. Call me, ask me why that price is what it is, how I can do it for that price, and I'm happy to have that discussion with you. But you've got to make the call, because believe me, it'll be a lot more expensive for your family and friends if you have to go to probate because you didn't have a living trust.
That's right. Remember, that's protectyourestate365.com or PYE365.com if you want to check that out, or reach out to Bill. His contact information, again, is below this video. Before we sign off, Bill, I was just looking up some information, and here we are in early July, mid-July here for this broadcast, and I don't know if you realize this, but about 5 years and a month ago, we first started this show, the Bottom Business Show. June 3rd was our first broadcast in 2014, and so this marks our 5th anniversary.
Wow!
And it's gone by incredibly fast.
Yeah, I was a lot younger then, but I know I want to give. I appreciate that. I did not know that was coming. Rick surprised me with that, but I want to give a shout out to him for all the hard work he's done on the sites, and the Bottle Business Sense show site and my sites, and with all of his video expertise and everything, making sure that this show could be provided to you. Remember, we don't get paid for this, so we volunteer our time to toot our own horns. And we do this to help others, and we want to give back to the community. And so for that, I express my thanks to Rick. And please take a look at our site, because we can be found not only in the Bottle Business Sense show, but on other social media, right, Rick?
That's right. You can find us on Twitter, Facebook, YouTube, and also on LinkedIn. Just keyword Bottled Business Sense Show, and you'll find us right there on social media as well. So
fantastic.
Yeah. So as always, everyone, we broadcast typically every other week on Tuesdays at 10 a.m. And if you missed the broadcast, you can always find us right here on our video blog at bottledbusinesssenseshow.com. So until next time, Bill, thanks again. And we will see you again next week, or next time here shortly.
Thanks. Take care, everybody. Have a great week.